And there's the note saying recording in progress. So I'm talking about powers of attorney today and joint accounts. I forgot to update the front page on that, but it is both things. So we're always going to start with a disclaimer because, as you know, I'm a lawyer and that's what we like to do. So what I'm providing today is not legal advice, and it's intended as a general presentation, so it might not apply in all circumstances. I'm trying to be as general as I can in what I'm talking about, but everyone has their own unique circumstances that kind of change things. So if you're hearing something I say and you want to say yes, but, then you're giving me something that's a different fact scenario, and it probably the general information doesn't apply. There's no confidentiality in this discussion because we're in a Zoom meeting with looks like 52 people right now. So anything you say isn't confidential. When we get to the question and answer section, I understand that the recording will stop, so at least that won't be public knowledge out on YouTube or anything like that, but you're still in a public setting in that sense. So I'm completely fine if people want to start their questions with, I have a friend who, or my brother-in-law is, or something like that. Even though if it's your personal situation, you don't have to tell everyone it's your personal situation. And about me, so I can tell you a bit about all of the letters after my name. The Certified Specialist is a Law Society of Ontario designation. The Bachelor of Laws from the University of Ottawa. I did a joint degree with the Michigan State University, and so I have a Canadian law degree and an American law degree. The CPCA is a Certified Professional Consultant on Aging. And that was one of the first things I did after law school, because as someone who was in my 30s, I didn't necessarily know everything about CDP, OAS, GIS, all of those great things that seniors and older adults need to worry about for the benefits they're entitled to with the government and their concerns. So that's why I did that. My Master's of Law is specializing in tax. Did that because tax hits estate planning a lot, because when you do good estate planning, you're being tax efficient, which all of us would like to do. The EPC is a state planners council. That's just for estate planners in Canada. And the TEP is an international designation. It's the Society of Trust and Estate Planners. So there's people all over the world with that designation. And we talk all about trusts, whether they're local in Canada or they're international. So powers of attorney. What are they? When are they used? How do you create one? That's what I'm going to go over first with you. So there's two kinds of power of attorney. There's the property, and then there's the personal care. They're used when you have capacity or when you don't have capacity. And to create one in writing, that's the only way that you can do it. So let's break that down more. I'm just going to move some stuff off my screen so I can see everything. There we go. Okay. So power of attorney for property is what I'm going to talk about first. I'll get to the power of attorney for healthcare after that. So a power of attorney for property is a document in which you name an adult or adults in charge of managing your assets. So when I say adult or adults, it has to be somebody over 18. You can name one person, you can name two, you can make three, you can name as many as you want. The first thing people usually ask me is it okay to name two or three or four? And I say, it's perfectly fine, you're allowed to. But when you're thinking about who you're naming, you have to think about how well they work together. And are you making it just too complicated for them to be able to deal with it? So if you have four people as your power of attorney for property, that means you need four people to make a decision. And so it sometimes means that decisions can take longer because you have to get an answer from all four. Now, one way to deal with that is when you're naming your powers of attorney, if you name more than one, you can say that they're joint, which means all of them have to sign and make the decision. They can be joint and several, which means any one of them can make a decision. Or if you have more than two, you can say a percentage. So you can, if you have more than two, you can say 50% to make a decision, or 50 plus one. So if you have three, then it's 2 of 3 to make a decision. You can also just say 2 of 3 or 3 of 4 to make a decision. So you can be quite creative about it if you want to have more than one or more than two to be able to do that. In my practice, generally I advise people for a power of attorney for property, you always want, if there's two, for them to be working together. You don't want someone accessing a bank account to do something without the other person knowing. That's how you can create conflict. And that's why then you need lawyers like me to get involved to help resolve that conflict, when you can make it work better if you just draft it properly and think about how those things will work together. The other thing I get people asking when, for advice for who they're naming, say they have 4 kids and either by tradition they want to name the oldest, or they're concerned about one of them because they don't manage their own money well, but they don't want to insult their child. My advice is always when you're picking the person is you need to pick the person who has the time and has the ability to do it. So you wouldn't want to pick someone that doesn't manage their own money well, because there's no way they're going to be able to manage your money well. They just don't have the skill set. Um, Location isn't as important as it used to be for power of attorney for property, because we can, thanks to COVID, we can do a lot of things online now. So if the best person you want to name doesn't live near you, that's okay. If they live out of the country, there's some other considerations we need to take into account. But if they're in Canada, it's okay. Pick the best person for the job. Your power of attorney for property can be limited or it can be general. So limited, there's two different ways you can do that. One way is for a specific thing or a specific time. So for example, before we had DocuSign and all of that stuff, and I was traveling, but my house was in the middle of being sold, I did a limited power of attorney for my father so that he could sign any agreement of purchase and sale that I instructed him to. They would still contact me, but he would have authority to be able to sign that because I was traveling. And when I returned, it expired. So it became my power again. So that's how you can limit it for a topic or a reason. And then time, that's simple. I can just say this is a power of attorney for property for 3 months or 6 months or whatever you want. General means it's good from when you sign it, and it's good until you revoke it or you die. So you can revoke a power of attorney for property at any time as long as you still have capacity to do something like that. A power of attorney can be used for property, can be used if you are capable or incapable or both, because you can switch between capacity and incapacity. So generally speaking, most powers of attorney for property can be used the moment they're signed. So they can be used in capacity and incapacity. So in that instance, you would never give it to the person you've named unless you wanted them to use it, because if someone has your power of attorney for property, there's no way for a bank or someone else to know if that is if they're allowed to use it or not, because they have the document. So we never give it to a person unless we want them to use it. Usually I house them here at the office. We don't release it unless you personally ask me to, or there's a doctor's note or something like that coming from the person you named saying that you're not capable of managing your affairs. One of the issues that we run into when people say, okay, I don't want this power of attorney to be good when I'm capable. I want it to be only good when I'm incapable, is that as people age and start to lose capacity to manage their financial affairs, there's like a range in there where it's very difficult to tell if you can or can't manage, because at some points of the day you're still completely fine, but other points you're not. You're quite susceptible to fraud or someone trying to convince you to do something. And if your power of attorney for property is based on your incapacity, the only way we can prove that is if you have a capacity assessment done. But you have the right to refuse to have a capacity assessment. So you can be in that phase where you need help, we need to protect you, we need to help you, but we can't because you're refusing to have a capacity assessment done. And then our only choice is to go to court to be able to deal with it. And of course, that's very expensive. So that's why I like the ones that are good when they're capable and incapable, but you just have that extra check and balance where the lawyer's office makes whoever you've named bring a doctor's note, or that you consent to it being released. The person that you name, so the person acting for you as the power of attorney, they have a fiduciary duty to manage your affairs responsibly. And fiduciary duty is actually a very strict standard under the law. So if the person is doing anything that personally benefits themselves, they can be removed and they can be forced to account for what they did and return the funds. I know sometimes out there people say, oh, I don't care, I can take it because I'll just claim bankruptcy after, and then they can't get anything from me. Well, at law in Ontario, if you have a fiduciary duty, you can't get out of paying something back because you declared bankruptcy. That debt stays with you to the day you die, and your estate pays it if it has to, or you pay it your entire life. So it's a very strict standard that's there and a very high level of responsibility on the person. And one tip for anyone who is a power of attorney, you must keep records of everything you do. Every financial transaction, everything you do, there must be a record and an explanation of what it is. I usually advise clients, if you're a power of attorney, you don't use cash because you can't prove what happened. So it's either Interact, credit card, check, e-transfers, whatever gives you a paper trail. So make sure you keep track of it. So the reason why the power of attorney for property is so important, but also so concerning if you name the wrong person, is because they can do everything that you can do with your finances except a couple of things. They can't make a will or change your will. They can't change any beneficiary designation, so like on your tax-free savings account or your RIF. And they can't act contrary to your will. They can do anything else. They can sell your property. They can deal with your investments. They can deal with your bank accounts. They can make gifts. They can make donations as long as there's a pattern or they know that you wanted that done. So it's quite powerful what they can do. So a power of attorney for personal care. This is healthcare decisions, but it's not just your healthcare decisions in the sense of if you're going to have a surgery or not, or someone's pulling the plug or something like that. There's more than that. They can make decisions on where you live, what level of care you have, not just the treatment decisions, but it even gets down to a level of like what clothes you wear, what things you keep with you if you're being moved to a nursing home. It's all of those kind of personal decisions for the person. So a power of attorney for personal care is also a document that you have to sign. You name someone in charge of making the decisions for you if you're not capable. So the biggest difference between the power of attorney for property and the power of attorney for personal care is that you have to be incapable of making the decision for the power of attorney for personal care to come into effect. So that's an important thing to remember. If you still understand what's going on and understand the totality of the decision that you're making, you're still obligated to make the decision. You're not allowed to say, oh, let my husband make it or let my wife make it. You have to make it yourself. You can also put restrictions in the document. And so I put example, a DNR on there. It's not the best example. I can tell you in my precedent, there's a clause that some people like that says, if I have something terminal, so we know that I'm going to die from whatever this is within the next 3 months, then I want you to let me go naturally at that time, which means no heroic measures, no CPR, no tubes, no nothing. Just let me go when I go naturally. So that's the most common thing that I see people put in. If you're someone who wants a DNR, it's actually well, it's good to put it in the power of attorney for personal care. If you want to make sure it's being restricted no matter what, you actually need to go to your doctor, fill out an Ontario government form, and then file that with the local EMS. Otherwise, they won't know. And unless your power of attorney is there to speak for you when something happens, they're going to revive you. So that's power of attorney for personal care. The other interesting thing about powers of attorney for personal care is you can verbally change your instructions. You can't change who you've named, but if you say you had no specific instructions in your power of attorney, so it didn't say what to do if you get hit by a bus, or if you're unconscious, or if you've got Alzheimer's or something like that, you can actually give a verbal instruction on that at any time as long as you still have capacity. So if you don't put any specific instructions in, but you talk to the person you've named and say, this is what I would want in these circumstances, then that's fine. That goes. It's completely fine. It's the only document that I ever talk about that can be edited verbally. The only caveat I say on that is if you're in the hospital and you've changed your mind about something, make sure they've written it down in your chart somewhere. You can't trust a nurse to have told someone else or done that. You have to make sure that's written down there and that your power of attorney knows, so there's no conflict between them for that. Just like the power of attorney for property, you can name as many people as you like. On this one, I say you can do joint and several, which means any to make a decision, or joint, whatever you're more comfortable with. If you're naming more than one person, I like the joint and several because if the hospital is calling or a healthcare provider is calling with an urgent decision, they don't need to find everyone and get the answer. It's just the first person to give them the answer. They can go with that. So it makes it a lot easier for a decision to be made quickly, but it's all up to your personal decision. And again, it's about who's best to make that decision. If you have someone if you're lucky and you have one kid who's an accountant, you have another kid who's in healthcare, you know exactly what you're going to do. Name the accountant, the power of attorney for property, name a first, and then name the other child who's in healthcare as your power of attorney for personal care. So it keeps it simple. All right, so how we create the power of attorney. It's in writing. It's usually done with a lawyer, but it doesn't have to be. There's a Government of Ontario kind of fill in the blank form that you can use. You can get it off the Government of Ontario website. It always has to have two witnesses who are not named in the document, and it's best if they're not related to the person that's named in the document. So, for example, if you named your son as your power of attorney, it's not a great idea to have your son's wife or husband to sign as the witness, because you don't want someone to be able to say that they were being unduly influenced when they did that, and they by you at that time. So if you're going to use the government produced documents, like just have neighbors be the witnesses. It's the easiest way to make sure that it's not someone related to who you've named. It's always a good idea to have them sign, print their name, and put their address in case they ever need to be contacted, and are swear an affidavit that yes, they were there and yes, they saw you sign it. I can tell you in my experience, most banks prefer to see a power of attorney that's prepared by a lawyer, because they just think that there's an extra check and balance because you've seen a lawyer, you've talked to them about it. When you see a lawyer do your powers of attorney, we ask you all sorts of questions to make sure we think you have capacity, like you understand what you're doing. But also you have to meet with us by yourself. So we hope that there's no undue influence. Like if you come to a lawyer to do your power of attorney and you bring your kids with you, if it's my office, I'm going to kick your kids out because I need to make sure what you're telling me is what you want to do, not what they want you to do. The other thing to be aware of is banks also prefer the power of attorney to be notarized or to be a certified true copy. That's the same thing, it's just a red seal we put on it saying that this is a true copy of the original. Banks don't like to hold or keep originals because they don't want to lose them. And so that's why they prefer to see that kind. What happens if you don't have a power of attorney? So it's different depending on if it's property or healthcare. So if you don't have a power of attorney for property, say you're hospitalized and you're unconscious, so it's easy. We know you're incapable because you can't talk. Then the hospital will, there's a special form for capacity assessments that they'll send to the public guardian trustee and let them know they have someone who can't make their own decisions, and they'll step in and make decisions. Now, if you as the family want to be able to make those decisions, if the public guardian trustee has already stepped in, you can actually contact them and they've got a different application procedure to take over from them, because I call them the PGT for short. They are the guardian of last resort. So if they've got someone who wants to be the guardian, no one else is contesting it. Like it's not like there's 5 siblings and one wants to do it, but the 4 say no. Then they can do it through their procedure and put that person in charge. They're going to have an obligation to account for what they do and all of that. If the public guardian trustee is not already in charge, then you would bring a court application called a guardianship application. That application serves the incapable person and all of the family. It says that you want to, or it can be more than one person, that you want to take over making decisions for this person because they're unconscious, they can't do it themselves anymore. And it includes a plan in there that the court approves, and you have to abide by that plan. And you have to do an accounting to the public guardian trustee every 3 to 5 years. It kind of depends. Guardianship applications are expensive. Right now, they're running over $5,000 in my practice for me to do it. But for me to just do powers of attorney for you, it's about $300. So it's worth the expense to get the power of attorney done, and then your family doesn't have to worry about the guardianship application. It's also time consuming. It takes on average 3 to 4 months to get a guardianship application done right now in the courts. Healthcare is a bit different. There's actually default legislation for it. So if you don't have a power of attorney for healthcare, there is the Healthcare Consent Act. And it lists out who can make decisions for you if you don't have a power of attorney. And in the hierarchy, it says a guardian. So if somebody applied for guardianship, then they can make the decision. If there isn't one, then a power of attorney. If there isn't one of those, the Consent and Capacity Board can actually appoint someone to make decisions. I'm not going to go into the consent and capacity board unless somebody asks me later, but it's where people go if there's a disagreement on how to care for someone or someone's capacity. The next person is a spouse or a partner. The definition is the broader definition, so common law partners are included in that. Then it's child. Parents only apply if it's to be able to make decisions if the person's 16, like if they're underage. And then brothers and sisters. So usually when I tell people, oh, great, there's a default act, and then I give them the hierarchy, they start realizing that there's people that will be allowed to make decisions for them that they wouldn't want to make decisions for them. So that's why you want the power of attorney. So you have a choice in who's going to make decisions for you. All right, so jointly held assets. Generally speaking, if a client comes to me and says, I'm thinking of switching my house ownership to be me and one of my children, I'd say no, and then I give them a whole bunch of reasons why. So I'll get into those reasons as we go through each of these points. So what does joint mean? Who owns it? Who can have access? What's the difference between bank accounts and real property? So when you make someone joint on an asset, any kind of asset, it means that person now owns, at a minimum, half of it. If not, have access to all of it. So when we're talking about this, when we talk about a bank account or real property, when you're looking at a bank account, and you add someone on as a joint owner to your bank account, they can access all of it. They can walk in the bank the next day and take all of the money out of that bank account. And besides you going to court to claim they weren't allowed to do that, the bank has no right to stop them because you've lost control because you made them a joint owner. This is why I like powers of attorney. Some people say, I'm adding my kid to my bank account to make it easier for them in managing my funds. But you could just do a power of attorney. They can have access to your account through the power of attorney. They then have that fiduciary obligation to make sure all the decisions they're making are for your benefit, not their benefit. When you do a joint ownership, you get none of those protections. It also means that if you do power of attorney and you're on the account as that, if the bank notices things going on that shouldn't be happening, they have the authority to freeze the account and block access to that power of attorney because they're a power of attorney and they're not supposed to be benefiting personally, and they know that. So you have more protection with a power of attorney than you do with joint. When we're talking about real property, so your houses, cottages, investment properties, any of that, when you deal with property, there's two ways you can be joint. It's called joint with right of survivorship, and then joint tenants. Joint with right of survivorship means that however many people are on title, the person who lives the longest gets the whole thing. It also means that during that time when all those people are alive, everyone has an undivided percentage share of the property. So if there was 3 people, it was an undivided 33.3% share of the property. What it really means is you can't divide that house in thirds and say each of you, like one person gets the basement, one gets the main floor, and one gets the upstairs. When it's joint with right of survivorship, you have a right to be everywhere in that house. Okay? Tenants in common means that if an owner dies, it goes into their estate. So if you have 2 people on title as tenants in common, one of them dies, the surviving owner doesn't get that other half. That half goes pursuant to that person's estate plan. And so you may now be a half owner with someone you didn't want to be a half owner with because of what that person's estate plan was. So joint with a right of survivorship means that the survivors get the whole thing. Tenants in common does not. It means it goes through someone's estate. When you're making an account joint at the bank, usually there's a box that says like joint, and then there's joint with the right of survivorship. There's usually an extra box to say if you get survivorship or not. When we're dealing with bank accounts and property that's joint with the right of survivorship, it means that it doesn't flow through your estate. So if you have 5 kids and you put 1 kid on as joint, that kid has the ability to claim they get everything and your estate plan doesn't apply. So there is a court case out there that says, no, if you transferred everything to one of your children and your estate plan says it goes to all 5, and there's not another document confirming you actually intended that child to have everything instead of being split 5 ways in your estate plan, then that's actually a resulting trust, which is the 4th thing on my list there. It makes it so that child's holding it in trust for the estate. The issue is banks don't know that, or they won't admit it. And the average population doesn't know that, but lawyers know that. And so you're creating a situation where you think, oh, I'm saving money. I don't have to pay probate fees and they can deal with it right away. It'll be great. But now you're going to pay the lawyer $100,000 to litigate the issue because the kid decided to say it was all theirs and your other 4 kids have to sue them to get their share. So it just doesn't make sense in that sense. What also means when you're joint is whoever you have added on that account, anyone can get to your money through them. So if you add your daughter and she hasn't paid her credit card bill in a year and they've sued her to pay it off, one of her assets to be able to collect on is your joint account because she's joint on the account with you and it's seen as her money as well. It also means that if there's a divorcing spouse, that asset's going to be put onto their list of assets. So if you're going to do something joint, you should paper it so we know what's supposed to be happening and what's going on. But you should really think, is paying a probate fee, which is 1.5%, worth the headache that you're creating and worth you losing all of the control that you have over your own asset? Because the other thing is, if you add a kid to your house, they can sell it the next day. There's something called the Partition and Sale Act, and it says any owner can sell the property. So if you didn't write anything else, you just added your kid, they could just take the house from underneath you if that's what they wanted to do. And then you'd have to pay a lawyer, litigate about it, and the lawyers would get rich because that's what you decided to do. So I always tell clients, you got to think about it hard. I very rarely get through that whole list of issues with them before they say never mind. There's small circumstances where it can be helpful. If you only have one kid anyways, it may be okay. If you have two kids and you're going to add both, it also might be okay. If you're one of those people that happen to know that when you're going to be passing away, then it's not as big of a deal. If you do it 6 months before you pass and everything's going to the kid you've added on as joint, then it doesn't matter as much that there's going to be that they might take it all because they're going to get it all in the end. They're just stealing from themselves in the end. So there are certain circumstances where it might make sense. The other thing to be aware of is bare trusts. You've probably seen that in the news recently because CRA changed the reporting requirements and then changed them back. But it was CRA's position that if you've added a child to your bank account or on your real property, and the intention is that it's not theirs, that they're just helping you, and that it should be split up pursuant to your estate, then you've created a bare trust. You now have to file tax returns every single year, along with Schedule 15, which lists all of the beneficiaries, which is presumably your kids, with their name, address, date of birth, social insurance number, and tax residency. So that was supposed to be due end of March this year. On the day before it was due, they said, okay, not bare trust this year. They didn't say if it's next year or not. They just said not this year. So we don't know if that's coming up. And so it's another big reason not to add a kid jointly to your account, because you don't want to add that reporting requirement to yourself, because the penalties are quite stiff. I think it's about 2,500 or a percentage of the value of what's in trust. So the penalty is actually one of the stiffest penalties that CRA has for not reporting on something. So the pros and cons of all of that, I think I've gone through in discussing that. Pros is that you can avoid probate. It might be a bit easier for a child to manage your accounts as a joint owner, but the cons are you're giving up your own ability to make decisions about your assets. You're potentially opening yourself up to the creditors of your child, and you're potentially opening yourself up for being called a bare trust and having further reporting requirements to CRA, and you're potentially creating a big issue with your estate at the end of the day. All right. I purposely tried to go a little short for you because I'm assuming that there's going to be tons of questions. So just remember in the questions section that you're in a public forum, so only disclose what you want to disclose.